Good morning, colleagues and honorable members. We are at 10 o'clock, of which our meeting needs to start. Before us, we have the following items that I will be presenting. It's opening, welcome, and introduction by the chairperson. Apologies as item number 2, and adoption of the agenda as item number 3. Then we'll be having a briefing by the Department of Defense on the Defense Amendment Bill, B32, 2025, Section 75. And the second one would be Military Discipline Supplementary Measures Amendment Bill, B31, 2025, Section 75. Then it will be committee discussions, way forward, announcement, and closure. With that being said, members, I put before your good selves this agenda as it has been shared on the screen. Today, we will be receiving a briefing from the Department of Defense, the Defense Amendment Bill, B32, 2025, Section 75, and Military Discipline Supplementary Measures Amendment Bill, B31, 2025, Section 75. These bills are being amended to comply with a Constitutional Court decision in the O'Brien matter. The Constitutional Court declared unconstitutional certain sections on the Military Discipline Supplementary Measures Amendment Bill, Section 15 and 17, and the Defense Act, Section 101 and 102. The minister was given 24 months to amend the legislation to give effect to the court decision, and this period expired on the 19th December 2026. So members, we're looking forward to listen to the engagement and deliberation and as well clarity from the Department of Defense. Before our good selves, we have in attendance the minister herself, and we had an indication that the deputy minister, Holomisa, will be joining. So I'm not sure if he has already joined, but we want to welcome everybody, Minister, and all the department and delegates. We have been indicated that the person who will be taking us through today's presentation is Mr. Sibu Sete. So before we get there, one would want to officially indicate that the meeting is opened, and now we'll go to item number 2, of which is apologies. Wuzela, can you take us through apologies that have been submitted prior to the meeting?
Thank you, Chairperson. From our side, we only received the apology from Defense Secretary of Defense, Mr. Bipin Timkulu. And then from the side of our members, we did not receive any apology. Thank you, Chair.
Thank you, Buzelwa. The agenda has been read and apologies have been indicated to us, all of us in the platform. Now I will move for adoption of the agenda. Members, I'm noting hands.
Sir, good morning.
Good morning, Honorable Nonkonyane.
Sorry, I'm trying to raise hands. I'm now clapping. Sorry, Chair. Good morning to you. Good morning to the honorable members and our guests. I rise, Chair, to move for adoption of both the apology as well as the agenda for this today's meeting. Thank you.
Thank you, Honorable Nonkonyane, the whip of the committee. Honorable Kotso.
Good morning, Chair, and good morning to all the colleagues and also the Minister and Deputy Minister and officials. I rise to second the adoption of the apologies as well as the agenda.
Thank you, Honorable Kotso. The agenda have been and apologies have been adopted and moved by Honorable Kotso. Thank you, members, for your participation, and thank you, Honorable Kim, for lowering your hand. Now the meeting is officially in process. We now move for the briefing by the Department of Defense on the Defense Amendment Bill, B32/2025, Section 75, and Military Discipline Supplementary Measures Amendment Bill, B31/2025, Section 75. Before we hand over to the department, would now give over to the Minister for her opening remarks, and then the Minister would then indicate who would be leading the department with regards to today's engagement. This is our first engagement with regards to matters before us. Honorable Minister, over to you.
No, thank you very much, Chair. And let me acknowledge honorable members on the platform, but also acknowledge our officials who have joined the platform. Just to clarify the apology of the Secretary for Defense, there are two clashing meetings today. The portfolio committees at the dockyard. So we agreed that one will go to attend the portfolio committee's meeting, and I will attend this one. I was in the same, I'm not sure if General Dolomis has been able to join because we are from another meeting with him, which now finished now at about 9:45. So I still hope that he'll be able to attend if he's not going to, has not gone to the dock yet. So I thought I should explain that. Chair, I really have to appreciate the opportunity now to take this matter to the NCOP. We've been through this bill over a long period of time with the portfolio committee and have gone through different iterations, and hence now the act has been referred to yourselves as the NCOP. So I don't want to take much time. As I said, we've been through this matter, and you, I think, eloquently or presented the context and the background of the process where we are, because we are already acting on some of the recommendations or are ready to implement some of the recommendations in terms of the appointment of judges, changing our legislation. So what now I think the leg we're at is the NCOP leg. The officials will take you through. Dr. Mnisi used to be the one leading, and I thought he would be here, but as I say, we have 3 clashing meetings now at the same time. So I will ask the officials from his office who have been given the responsibility to present. Chairman, still audible? Or have disappeared?
Yes, you are.
Yes,
I had some challenges to hear you as well, so you can continue. We
I
have
can
heard
continue.
you while you were handing over to the department.
Yeah. Let me hand over to the department chair and then sort out my gadget. But we are ready to present. So I'll ask the department to present, and then we will come at the end when there's engagement. Thank you very much, Chair.
Thank you, Minister. Before they continue in terms of their presentation, let me just indicate, members, that before us, we have as well invited the Parliament legal advisor and the state law. State law is Sarah Govenda, and Parliament legal advisor is Mushokwa Timothy van der Bireda. So we have those before we are in our meeting, so that as we process this matter, we are able to be assisted by their good selves in terms of legalities. Over to you, Department of Defense.
Just to indicate, Chair, that Honorable Olomisa attended the portfolio committee. I'm here. Richard, Deputy Minister.
Thank you, Deputy Minister, and we know that you always supported this select committee. You have been noted as the person we have attended. Sorry for omission, because I thought that Minister Olomisa would be with us today, as we got the indication from the PLO. But we thank you yourself for your presence today. We can now hand over to the Department of Defense for both presentation. Thank you.
Good morning, Chair. Good morning, ministers and other members of the committee. Am I audible?
Yes, you are.
Thank you very much. I am Advocate Kameshni Ramcharan. I am Director Legal Advice in the Defense Legal Services Division. This morning, I'm joined by my colleagues from the division, in particular, Lieutenant Colonel Mashego, who's going to present to you the amendments to the both affected bills, ma'am. May we kindly proceed?
Yes, please. Can you just make it seamless for the first bill and the second one?
Very seamless, ma'am. It's very, very straightforward. Thank you. We will start by giving the background into it very briefly, and then I'll hand over the presentation to Lieutenant Colonel Mashego. Thank you, ma'am.
Thank you.
Morning, Honorable Chairperson of the Select Committee. Morning, Minister and Deputy Minister, all protocol observed. I would start with the presentation on the Defense Amendment Bill. But when we look at the presentations for both the bills, the background is the same for both the bills because they were affected by the same court matter of O'Brien. The matter of O'Brien approved the Constitutional Court, claiming that there is interference from the executive and the unconstitutionality of certain provisions of both the Defense Act as well as the Military Defense and Military Discipline Supplementary Measures Act. Starting with the Defense Act, only one clause was affected, that being a clause that allows the minister to convene boards of inquiry on any other member. And the court then decided that in the application of clause 101, 102, 103, that convening a board of inquiry should not include or must not be explained as including the activities of military judges. In other words, the judges, when they are in court, they cannot be investigated through a board of inquiry, and that gave rise to
General, sorry for interruption. Sorry for interruption. I see the hand of Honorable Noe. Honorable Noe.
Chairperson, thank you very much. I'm sorry. I don't know what is the protocol now. We don't see the document on the screens that the general is speaking to. Thank you.
Okay, thank you. Noted. I actually wanted to indicate as well that can we have the presentation flighted, even though we know that members got the presentation prior to this meeting. So as procedures dictates, we normally like to follow through because of we have TMG with us and as well members who are following this session on YouTube. So it is important that we flight the presentation and we speak to the presentation. Thank you. Mr. Mashiro, can I?
Honorable member, I'm not in a position to flight it here from my side, but I think maybe the secretary for the select committee could assist us on that side, if possible.
I'm trying to assist you. I have sent Puzelwa the text because we are virtual, so we are not on the same premises. So I would just indicate, or we'll see if the presentation will be flighted. You can continue. The presentation has been flighted.
Okay, thank you. That is the scope. Can we go to the next slide? Thank you, Honorable Chairperson. Pertaining to the Defence Act, Section 101 of the Defence Act was found to be unconstitutional to the extent that it empowers the Minister, the Secretary for Defence, or the Chief of the Defence Force that they may at any time or place convene a board of inquiry to inquire into any matter concerning the department, any employee thereof. The reference to any employee was found to be unconstitutional so far as if it also includes a military judge who is sitting in court, that the decisions or the language or whatever spoken by the judge cannot be investigated through a board of inquiry, because that's what Lieutenant Colonel O'Brien approached the court to say that he was brought to a board of inquiry based on what he said when he was presiding over a matter. Next slide. This case that transpired or was finalized in December of 2024, the court gave the department a period of 2 years to correct legislation. But sometime in the course of this year, the department approached the court once more on certain matters, but then the court in response, it gave the department an extension of 6 months to correct the legislation. The initial due date for the department to have finalized the correction of legislation was 2026 December, but now with the addition of the 6 months, it will be 2027 June. And as a result of what then the court found in relation to Section 101, the Defense Amendment Bill was written, it was consulted through all the relevant parties, up to and including the Portfolio Committee, wherein the bill was presented. You will see when you go on another document being the bill itself, you know that the bill is so short because only one clause was affected, being Section 101. But then the department, in correcting that, has inserted a clause under Section 102, and there's a capital 102A. Let me go through to 102. That the president of the board may summon any person, where the term any person is couched in the act. It has been resolved with the inclusion of a new clause which reads that the exclusion of military judge and senior military judge from board of inquiry. The wording of Section 102, capital A, it reads as follows: a board of inquiry contemplated in Section 101 and Section 102 does not apply to a military judge or senior military judge referred to in the Military Discipline Supplementary Measures Act of 1999, and also does not apply to the content and the merits of the judgment or their rulings. So the insertion of 102 is to correct the interpretation in Section 101 and Section 102 of the Defense Act, wherein, as I had said, Section 101, it gives the Minister, the Secretary for Defense, and the Chief of the Defense Force authority to convene a board of inquiry on any person. Whereas 102, it specifically says the president of the board of inquiry may summon any person to give evidence. By inserting 102 capital A, we are correcting only the interpretation, because you will see that when you read Section 101 and 102, it does not specify anywhere that including the military judges, but the understanding and interpretation of any person, therefore, it also includes military judges when they are presiding, when they are in court. Section 102A, it corrects the interpretation of 101 and 102, that any person does not include a military judge when they are presiding. The other correction on the Defense Act, you would note it's Section 1, which read, the heading therefore, which read that attendance of persons at board of inquiry. Instead of writing inquiry with I, the Act is written inquiry with E. So we are also correcting that to say it must read inquiry rather than inquiry. And the other clauses, clause 3 of the Defense Amendment, is the arrangement of sections, which also then will include the heading exclusion of military judge and senior military judge from board of inquiry. That is all about the Defense Amendment Bill. that it has about 4 sections. The first section is to correct the terminology, the inquiry to inquiry. The second section speaks to the exclusion of a military judge from boards of inquiry when they are presiding, and including their content and their rulings. It means that if there is an issue with what a judge says in court, other processes or other due court processes may have to be followed. That cannot be cured by any of the executive members convening a board to investigate a particular military judge. Honorable Chairperson, I thank you concerning the Defense Amendment Bill. If you allow me to go to the next one, I will wait for your permission. Thank you.
Thank you. You can continue.
Thank you, Honorable Chairperson. With the same background, if you would allow me to go directly to the bill. When we look at clause, with your permission, Honorable Chairperson, I'm going directly to the bill. This bill, the Military Discipline Supplementary Measures Amendment Bill, the court found a few clauses to be unconstitutional, specifically clause 15 and 17. Clause 15, it reads as follows, the current before the amendment. It says period of assignment as the heading. An assignment in terms of this chapter shall be for a fixed period or coupled to a specific deployment or operation. And then the Concord ordered that the minister must amend this particular section because it affected the question of security of tenure for military judges. And in doing so, the bill then attempts to correct the specific clause. Then there is also section 17. I will go back to section 15. There is also section 17, which was affected also by the decision of the court, which speaks to the removal from assignment. That the minister, acting upon the recommendation of the Adjutant General, may remove a person from the assignment. That also was found to be unconstitutional. And then the department, after consultations, came up with a bill to correct that position. And as a result, other portions of the act also had to be amended so as they can be in line with the two sections that were specifically mentioned in the judgment. Honorable Chairperson, I'm going right to the first clause of the amendment in the bill. In clause 1 of the bill, the department has opted to come up with a committee that would be responsible to recommend to the minister on the assignment of military judges, on the removal of military judges, and also it provides a security of tenure as to how long must a judge be on the seat as a military judge. Previously, the Act did not specify any period, but now with this amendment, we are proposing that the Act must specify, so that then the military judge may have that security of tenure to say, once you are a judge, you cannot just be removed without certain specific reasons like fitness and proper or any other reason. If ever there is a need to remove a military judge, it would not be on the recommendations of an adjutant general, but it will be the responsibilities of an independent committee, which is established now by legislation as it is couched and as I will go through the bill. Section 1, therefore, we are including this new institution that is being established, which is called the Military Judicial Advisory Committee. And in Section 1, we are including it as a new definition. Then where it says committee in the bill, then it refers to this newly established Military Judicial Advisory Committee, which is established in terms of Section 6, capital A. Clause 2 of the Military Discipline Supplementary Measures Amendment Bill, it talks about the establishment of the committee. It says the heading thereof, establishment and composition of the committee. 6A1 says there is hereby established a military judicial advisory committee. The committee, then the bill tells that it consists of a judge of the High Court designated by the Chief Justice, a practicing senior counsel designated by the South African Law Legal Practice Council, a practicing advocate designated by the same Legal Practice Council, a practicing attorney also designated by the Legal Practice Council, and a legal academic designated by the Society for Law Teachers of South Africa. What then this committee will do, instead of the Adjutant General being responsible for the assignment of military judges and the movement of military judges, that responsibility then is thrown into the hands of the committee, which the minister will have to establish. And in that way, there will not be interference from the executive to decide who must go, who must not go. This committee will attend to the shortlisting, will attend to the interviewing of members to be assigned to the functions of military judge or senior military judges in the Defense Force. Section 6B, it talks to the functions of the committee, and it provides for regulations to be made which will guide how the committee receives nominations, which must be submitted to the Adjutant General's office, how to provide a recommendation to the minister on the assignment or the removal of military judges. Maybe before I continue, I may need to also explain to the Honorable Committee that when we speak of assignment of of judges, it is different from appointment. A person is appointed into the South African National Defense Force, and they serve as a military officer. Within the South African National Defence Force, there is a division that is called the Defence Legal Services Division. Within this division, there is a component that deals with military justice. And under military justice, you will have director military judges, director military prosecutions, director military defense counsels. So those who become military judges, they are not appointed to be military judges, but they are assigned a responsibility. They are assigned a function. That is why we speak about assignment of military judges to the function of military judge or senior military judges. I just wanted to bring that to the attention of the committee, that we are talking of assignment and not of appointment of military judges, because already they have been appointed to be members of the South African National Defence Force. So Section 6B, Section 6 capital B, it talks to the functions of the committee. They must receive nominations. They must provide recommendations to the minister on the assignment of officers and also of the removal. Previously, the Adjutant General will recommend to the minister the removal, and there seemed not to be a process in place to guide the Adjutant General in removing members as military judges. And what this section then does, it empowers this committee that is established in terms of 6 capital A, then to have that powers of recommending to the minister the removal of a military judge from their function. And at least it's an establishment, it's an independent established body which is made up of the persons that are mentioned in Section 6 capital A. Further, the committee will receive and consider any complaints that are brought against military judges on matters of incapacity, gross incompetence, gross misconduct, which emanates from their judicial functions. You will remember that in the defense amendment, we spoke about judges being excluded from boards of inquiry. So if there is any issue that one wants to bring against military judges, the process will be to approach the Military Judicial Advisory Committee and lay a complaint with the establishment. It will investigate, and it's in a better position to can give a recommendation to the minister. Further, the committee must consider whether a judge is a fit and a proper person to hold office. Previously, it will be only one person, being the Adjutant General, who would do that without specified processes to be followed, but now it is the responsibility of this committee. Further, they may consider objections against the assignment of any military judge or senior military judge. Any objections that may be raised by members of the South African National Defence Force on a particular assigned judge. So those are the functions which are covered under the inserted section on clause 6. And then 6 capital C, Honorable Chairperson and members, it speaks directly to the issue of remuneration and expenses of this particular committee, that the committee may be paid such allowances for traveling and subsistence, which is incurred in the performance of their functions, as the minister may determine with the concurrence of the Minister of Finance. But of importance, honorable members, is that Section 6.2, it tells that members of the committee referred in Section 6, capital A2, B, C, D, and E, may be paid such remuneration, including allowances and traveling, because they are deemed to be already members that are under the payroll of government. Honorable Chairperson, 6D, the insertion of 6D, it talks to the term of office of the members of the committee, that these members shall be appointed for a period of 5 years, and such appointment may be withdrawn by the minister at any time. And further, that any person who's been appointed to the committee, whose term of office expired, may be reappointed by the minister for a further term of 5 years. So the inclusion or the insertion of this section of the committee, it goes to the position where the minister has to assign members of the Defence Force as military judges, that it shouldn't be a process that is being attended to by a single individual, but it should be a process that is provided for by an independent committee that is made up of a judge, counsels, an attorney, and a person from the legal academia. That's how those sections go. The next amendment is Section 14. Section 14 it's of the Defense of the Military Discipline Supplementary Measures Act. It provides it provides that by the substitution in subsection 1 for paragraph B of the following paragraph, paragraph B of subsection 1 of section 14 read that of senior military judge or military judge, okay, from section 14. Let me read it for you from section 14 so that we can follow it. Section 14 speaks to the minister's powers in respect of assignment. Section 14.1 read, the minister shall assign officers to the functions. A, it says at the level of directors. B, it says of senior military judge or military judge referred in section 13A. On the recommendations of the adjutant general. So there, the adjutant general is substituted with the committee when it refers to assigning of senior military judge or military judge. So we are then deleting the responsibility of being recommended to by the adjutant general. So that is to correct that clause so that it can be in line with the judgment of the Constitutional Court. So Section 14 is hereby amended by the substitution of subsection 1 for paragraph B of the following. And the word there, senior military judge, is being deleted as referred to in section 13(2)(a). The second one, Honorable Chairperson, is the amendment under subsection 2. You'll see when you go to subsection 2, it says the Adjutant General shall recommend any officer for assignment to any function referred to subsection 1B, rather to subsection 1, unless upon due and diligent inquiry, the Adjutant General is convinced that the officer is a fit and proper person of a sound mind. Now, subsection 2, we are deleting the words Adjutant General and we are inserting the words the committee. And then it reads that the committee shall recommend any officer for assignment to any function referred to in subsection 1B. Subsection 1B, that's the one that I referred to earlier on. It makes reference to a military judge or a senior military judge. So when it comes to the recommendation for assignment of military judge or senior military judge, it is the committee and not the Adjutant General who will make the recommendation to the minister for the assignment. Then going to the next section, which is section 15 of the Act. The current section 15 of the Act, it reads.
Chair, can I have a word? Sorry, General. I have my hand up there.
Yeah, but if I haven't noted you, you can't open your mic in terms of our protocol and procedure. You can speak, Honorable Pete.
Chair, I'm sorry. I realize you are not noticing me, and I'm sorry. I apologize. But Chair, I think this is injustice. I looked at the documents that have been sent to us. The one that the general is addressing, even the one that you are showing here, there is no correlation. Can we be taken to the right document based on what is being presented? Because general is now dealing with the bill and quoting sections. All the three documents I have, I don't see one out of them. And you said you've got our law advisor here. I'm not sure in front of him or her which document is he looking at, or other members. I'm sorry if it's not, it's only me who is not following the presentation based on which document.
Thank you, Honorable Pitso. We heard you. I think what has been happening is that the general is presenting on the summary presentation that they have done, referring to the two documents that we have been given of Defense Amendment Bill, B 32B 2025, and as well Military Discipline Supplementary Measures Amendment Bill. So he has been referring on sections based on these particular two bills. So you would need to use all these three documents to refer to. I'm not sure if it's your only your good selves that you've been not being able to follow through in that way. But I think with what has been presented and as the presentation has been going through, one has been following on the side based on the presentation as he has been making reference. So you just need to use those two ones to check in terms of indications where the changes have been effected.
Yeah, Chair, I'm saying what you are showing there on the screen It's not what the general is speaking to. Now, I'm saying, I'm looking at the bills, both of them. I can't see the one that the general is presenting. So I'm just asking that maybe where he is now, we should just be assisted. If it's only me, I am asking, can I be assisted? Which area of which document and which, because I'm looking at the bill itself and the presentation, the areas where the general is speaking to. I can't see them there. Either I'm having a wrong document or I can't find the right document.
No, you have a proper document, don't worry.
So can I be assisted so that I follow, not just I register things that have been presented, but I don't see the document.
Thank you, Honorable Pito. General, can you just emphasize perhaps in terms of making reference with members on which page can they check, like page 55 and so that they must not lose you. I just want to just confirm as well if this slide where we at, it's what you've been just presenting now.
Yes,
So,
yes.
okay. Yeah. So
Sorry, yes. Okay, sorry.
You can continue. So if you are where you have been presenting, it's fine. Refer to members in terms of the pages of the documents that have been sent through by your department for ease of reference, so that they must not lose the full.
Thank you, Honorable Chairperson. May we go back to the previous slide? The other previous slide. Thank you, Honorable Chairperson. On that slide, we have covered the two amendments. That is the committee, which I have explained that is a definition of the committee that is established in section 6A. And then the following slide, then it tells what has been done. Following slide. There is establishment in section 6, capital A, and composition, and I have read to the Honorable Committee the members that make up that committee. That is from the judge right through to the legal academia, if members can follow. That is section 6A. Then section 6B, it refers to the functions of the committee. In the presentation, we didn't want to copy the bill as is, because then it would be a very big presentation. Perhaps we must apologize for not putting all the contents of the bill under the presentation. And then 6C, it refers to the remuneration of the members of the committee, which I have spoken to. So when I present, I would read the portion of what is written there on the presentation, but I speak directly to the content of the bill as it stands. So section 6D, the insertion of 6D, it speaks to the term of office. The term of office for members of the committee, honorable members. And then for us to understand what I'm talking of in section 14, we need to note that it becomes a consequential amendment, section 14. It is not what the Constitutional Court decided on. It is affected because of certain clauses being amended, wherein now it is the functions of the committee to recommend to the minister the assignment and or the removal of military judges. Then we had to then go directly to those clauses. Perhaps I must apologize for not writing and showing amendments on section 14 on the presentation. I just went directly to section 15 and section 17. So section 14, it's all about it to substitute the Adjutant General from recommending to the minister when it comes to the assignment as well as the removal of military judges, and it's been substituted by the committee that is established under section 6A. So now I am at section 15, which is headed period of assignment. And I am reading from the act that is being amended. This is the current act, the Military Discipline Supplementary Measures Act. Section 15 of it says, an assignment in terms of this chapter shall be for a fixed period or coupled to a specific deployment or operation or exercise. That's what it provides, the current act. And the bill then substitutes that two-liner section of the current act as it stands with an insertion of a new 15. The new 15 reads as follows: with the exception of the period of assignment of military judges and senior military judges as contemplated in subsection 2. Then it tells an assignment in terms of this shall be for a fixed period or coupled to a specific deployment, operation, or exercise. Then 2 says, subject to subsection 3, the minister must assign upon the recommendation of the committee. So the committee is playing a role now, from now on any responsibility that has to do with the military judges. To the function of military judge or senior military judge for a non-renewable term of 7 years. This is a new inclusion. The previous one, as I read to the honorable committee earlier on, it said an assignment shall be for a fixed period or coupled to a specific employment. As part of security of tenure, now the bill and the act will provide that military judges will be in that specific function no longer for the period as stated in the current act, but shall be assigned for a period of 7 years, and that period is non-renewable. Then 3A says an officer assigned in terms of subsection 2 must perform their functions of a military judge until such time that he or she completes the 7-year assignment period, or until he or she reaches the age of retirement or his or her contract of employment expires, whichever occurs first. So now it is certain and determined that the period of assignment as a military judge is not just for a fixed period or coupled to a specific employment. It's for a non-renewable term of 7 years. Then subsection 3, then it tells until when this period is determined. If the person reaches the age of retirement, then the member will go to retirement even if they had not finished the 7 years tenure. Why? Because if a member reaches an age of retirement in the Defence Force, which is 60, then the member is automatically out of the system. Some members will then go into the reserve force, but then the challenge is in the reserve force, you have to be called to come and be a participant or a member of the legal services. It's not automatic. It's based on a need arising for you to be called. So once you retire, if you were to retire once you had served as a military judge for 6 years, then it means that because now you are out of the system, then you are no longer a military judge. On the other hand, it could happen that you have been assigned a military judge, but then your contract of employment comes to an end. We have members within the Defence Force that are on contract basis. If your contract was to end whilst you are still serving as a military judge, it means that you are no longer in the employ of the Defence Force, and therefore your service and your responsibilities in the function of the military judge will then come to an end. Whichever comes first. So that's what that means. But at least then it has given that security of tenure when it comes to the period of employment, rather than when in the past the Adjutant General will just determine that you are a military judge for 3 months, and then the next thing you are no longer a military judge or something, and then after some time you come back as a military judge, which created a little bit of confusion. So with this amendment, it clears the uncertainty as to how long must a military judge.
Colonel,
Yes, ma'am.
as you proceed, because I got an indication from Honorable Norway that he's still experiencing some confusion. I can see these are synopses based on what we have on the amendment bill. So what you need to do, as I said, as you emphasize, for instance, term of office members of committee, we would go to page 4 and indicate the following to say that substitute of section 15 as you've been doing, and then you indicate the area that you are reading through as a matter of emphasis.
Okay, thanks, ma'am. Thank you. Sorry for that. Yes, we are under page 4 of the bill. Page 4 of the bill, which refers to substitution of section 15. The section 15, I have already read it, the 2 sentence, that it is substituted with a new section 15, which is clause 4 on the amendment bill, which is under page 4. Thank you, Honorable Chairperson. So, yes, I was still under the period of assignment, that now there is certainty as to the length of the period of assignment. I'm going to the following one, Honorable Chairperson. I'm going to section 17, which is also on the bill on the same page, page 4. It is clause 5 of the bill, of the current bill. It's a substitution of section 17. And then I'm going, honorable members, to the current reading of the act that is being amended. It reads removal of assignment, and section 17 reads as follows: the minister, acting upon the recommendations of the Adjutant General, may remove a person from the function assigned to him or her for the reason of that assignee's incapacity, incompetence, or misconduct, or at his or her own written request. This is the current section 17 in the act that is being amended. And then in the bill, page 4, clause 5, it reads that removal from assignment, the minister may remove an assigned officer from the function of the military judge or senior military judge if the committee, after affording the military judge or senior military judge a reasonable opportunity to be heard, recommends in terms of section 6B his or her removal for reasons contemplated in section 6 capital B, that is para C or D. This is the insertion. It relates to section 6. Remember, section 6 establishes the committee. It also gives the functions. Section 6 capital B, it's on the functions of the committee. So now it no longer says the minister as recommended by the committee, but then it says the minister may remove an assigned person from the functions if the committee now then it shows that the committee will call the member, will hear the member, will investigate with the member, and then after affording the member a reasonable time and opportunity to be heard, then a decision will be taken and a recommendation will be made. At least now with this bill, it provides a process that must be undertaken before a member may be removed from the functions of a military judge or a senior military judge, whereas previously it was only the Adjutant General recommending to the minister, and there is no process that is stipulated in legislation. And then still under removal of assignment, clause 2, then it says the minister acting upon the recommendations of the Adjutant General. This is the current reading of the act. And it is only amended by including the underlined sentence, which reads, excluding an officer contemplated in section 1. I will read subsection 2 in full so that you can hear what it says. The minister, acting upon the recommendations of the Adjutant General, may remove a person initially it read may remove a person from the function, but now it would read may remove a person excluding an officer contemplated in subsection 1. Subsection 1 speaks to a military judge and a senior military judge. So it means the Adjutant General would continue to have his recommendations to the minister, either for the removal of other assignees, excluding the military judges, because there are other assignees within the military judicial system, which may include defense counsels, prosecutors, and other role players. May I move on? Thank you, Honorable Chairperson.
You can move on, Colonel. And now I'm noticing why there's been so confusion. You see, with your
Yes.
presentation as well, when you go on the slides, we are from
Yes.
13, now we are on 12. So next time when we must just make sure that everything that we send to members of the committee, it's properly following. Because of this thing of they are losing you when you present, it's on the basis of how pages have been labeled. So you can continue.
Noted, Honorable Chairperson. And then the following one under section 17, removal of military judges, then it refers to other consequential amendments that were affected. Like section 44, still under page 4, it says section 44 of the Principal Act is amended by the addition of the following section, and subsection 5 is added. It says any regulations made under section 6B must, before publication in the Gazette, be tabled in Parliament. When you go back, Honorable Chairperson, to 6B, you realize that it creates the need for regulations to be made. The very first sentence, if members go back to page 3 of the bill itself, under functions of the committee, 6B, it says the committee, in the manner prescribed by regulation, must receive all nominations submitted to the office of the Adjutant General in the manner prescribed. So where section 44, then it creates a responsibility to the minister, that where the minister makes regulations under section 6B, such regulations, before they can be published in the Government Gazette, they must be tabled in Parliament. That's what section amendment of section 44 provides. Then going to the next, also consequential, going to the next page on the bill itself, page 5 of the bill, is the amendment of arrangement of sections of this Act 16 of 1999. The arrangement of sections in the Principal Act is hereby amended by the insertion after the item relating to section 6 of the following items. Then it will insert section 6 capital A, which is the establishment and composition of the committee, the Military Judicial Advisory Committee. And then 6B, capital B, which speaks to the functions of the committee. 6 capital C, the remuneration and expenses of members of the committee. In section of 6, capital D, the term of office of members of the committee. That is the rearrangement of the sections under the Principal Act, the Military Discipline Supplementary Measures Act of 16 of 1999. Then, Honorable Chairperson, still under page 5 of the bill itself. Then there is the short title and the commencement of the act, which reads, this act is called the Military Discipline Supplementary Measures Amendment Act 2026, and it comes into operation on a date fixed by the President by proclamation in the Gazette. Honorable Chairperson, based on the presentation that is before the Honorable Committee, those are the amendments that have been made to the Principal Act. And I will take members to almost the second last slide, decisions required. There we have written and noted that for the NCOP to support the bill, the very last, second last page. Can you move second last page? That's a summary. Second last page, those are processes that were taken before the bill could go to Parliament. Second last year. So the decisions required by the department is for the NCOP to support the bill and recommend its approval and or assent by the President. Honorable Chairperson, we thank you for the opportunity to present the bill before the esteemed committee, and we are at your liberty for any questions that may arise. My colleagues are here with me. Thank you very much, ma'am.
Thank you, Colonel. Before I hand over to the committee, I just want to check if the minister would want to say one or two.
Not, Chair, not at all. I'm fine. Thank you very much, too.
Thank you, Minister. We know the presentation and the amendment bill made to both the bills that addresses the constitutional concerns, which addresses issues of the appointment and periods of appointment of the military judges, and the establishment of the Military Advisory Committee and the Military Judicial Advisory Committee, with a list of those who will form part of the composition of the committee, amongst others, and this amendment appeared to strengthen operations within the Defence Force. So we thank you as well for giving us a presentation on the background, the aim, and what has been done to effect the changes on these particular bills. Now I would like to hand over to members for clarity-seeking questions and as well inputs, because we know that this bill has came before us so that the NCOP can consider, so we can as well do our process of exhausting public participation before the approval of this particular bill. So I want to note the hands of the members with regards to presentation given before us. Honorable Offense, Honorable Gerik, and Honorable Nonkonyan. I only have 3 hands that I've noted. Members, I would give now to Honorable Mukai.
Good morning, Chairperson. Good morning to the honorable members. Chair, can you hear me?
Yeah, I can hear you and you look proper.
No, thank you very much. Thank you. Just let me know if my bandwidth is, I'm still at Acacia, that I switch off the video.
Just switch off the video, then you can continue.
All right. No, thank you very much, Honorable Chairperson. Thank you and good morning to the honorable members of the committee, our support staff. Also, good morning to the honorable minister and all the officials and the generals from the defense. Chair, noting that the process for this bill, and as the minister and as you have also alluded, it emanates from various processes. One being the issue of the court processes, as initiated by Dr. O'Brien. I want to find out from the department in terms of how we've been proceeding with the two pieces of legislation. What are some of the key contestations that have emanated, maybe that the department has picked up when processing this bill, and has they led to maybe amending some of the clauses in the two pieces of legislation? Because Chair, you all know that, sometimes we will think that you're moving in the right direction, but there will be those who will question or maybe even assist the process to say, look, you are still not addressing key gaps in this piece of legislation. So my question to the department, in terms of how you've been processing this bill, I know that it has gone through the National Assembly. Has there been any contestation and challenges maybe the department has picked up to look at amending or adding stuff in the legislation? I know, Chair, that we are also going to undergo our own processes, including public participation and receiving inputs, but it will really empower us to make sure those, if there are gaps that have been identified, we close them in time. Thank you very much, Chairperson. That will be my inputs for now.
Thank you, Honorable Mukai. Honorable Kherik.
Chairperson, good morning once again to you, to the minister, to the officials, and also to the honorable colleagues. Thank you for the opportunity, and thank you for the presentation. It highlights a lot of things, and we also take note of the process that has been followed, and also the ruling by the Constitutional Court, the judgment, taking in consideration administrative law, administrative justice, and also procedural law. So I just want to understand now what the process is going forward, and the timelines. Is there a return date to the court so that the court may ratify, or will it be the work of Parliament to ratify the amendments? And what will be the timelines? Thank you, Chairperson.
Thank you, Honorable Kherik. Honorable Phala.
Thank you, Chair, and good morning, honourable members, and good morning to the Minister and the senior officials of the department. Chair, as you indicated in your opening remarks that it is the first time we have this matter in front of the committee. And there are serious issues here, which the presenter or the department has presented. But the core issues here are, as a result of the Constitutional Court, which held that the challenge sections did not give effect to the constitutional requirements of the judicial independence insofar as they are concerned, and on three areas: the appointment and tenure of military court judges, Secondly, the independence of the operations of military courts, and the shielding, the last one, which is the shielding of the judgments handed down by the military court judges. This is a complex matter, and as you alluded and said, this is the first time being in front of us here. Many of us were lost here in the presentation, and from my side, I was not able really to contribute effectively. I would propose that we visit this matter as the committee members. We sit and properly be advised by the Parliament legal unit on all these issues, so that we should able to take proper decisions. And this shouldn't just be a malicious compliance. It's a complex matter which may have a far-reaching implications to the executive and also to the senior management of the defense. So I would really say we need to revisit this, and with the proper advices by our researchers, and including the legal, the parliamentary legal unit. That's what I wanted to say, and thank you, Chair.
Honorable Nonkonyane.
Chairperson, Honorable Minister and your team and colleagues, good morning again. And for the first and foremost, thank you, Honorable Minister, for the presentation by your delegation. I've got one question, but before that, I need to make this one. We did, honorable members, receive the entire bill, and with an indication of those sections that were amended, either removed or amended, as the presenter pointed out. And we then again, last Monday, received a summary of really the synopsis of what has happened. I agree that members, we need to revisit that and make sure that when we have our own deliberation, having gone through the bill line by line, because there's a principal act, the proposed amendments, they are underlined. It's very, very clear to follow them. And at the end, at the beginning, they will tell you that we intend to remove this, we intend to substitute this. There's also a format around that. Then my slight question, before that, thank you very much, Minister, and your team. I'm very, very impressed about the presentation, because it's quite clear that we must understand the mischief rule in any amendment of any piece of legislation. We must determine what is the mischief that the bill intends to correct. And we know that there's O'Brien's matter, which went to Constitutional Court, and we know that the Constitutional Court was very, very specific that in terms of certain sections, they must be amended. As honorable members correctly pointed out, to assert the independence of the judiciary, because we can't have a judge that is being judged by a person who has no clue on legal issues. Hence, I think the formulation that I've read clearly assists us to address exactly that mischief. Hence, I'm thankful. But there are one thing that I would like that the presenters, Honorable Minister, through you, to explain to us. A judge of the High Court amongst this committee, in fact, let me start with Military Judicial Advisory Committee is a good thing. But the question of its composition, that's where I want clarity. I've not taken a position on that, but I will seek clarity. One, there is a judge of the High Court that must be designated by the Chief Justice. And you will see then that the senior counsel, there's also an attorney, etc., about the Legal Practice Council, LPC. We understand those structures. But my question is, why, in respect of a designated judge, we give designation to an individual, the Chief Justice, as opposed to the appointment of the senior counsel as others to LPC, not the chairperson of the LPC, for instance? There may be a reason, because the judge may have been appointed by the Judicial Service Commission, perhaps, but I need your clarity. What is the rationale? Because we seem to differentiate. The others are appointed by a structure, but the chair is appointed by an individual, albeit, of course, is the head of the judiciary in South Africa, which is really a good point. That's one thing. The other one, I see then that that military judicial advisory committee is composed of entirely legal gurus, including academics, which is good. But what I don't understand, which I would like clarity, is we're dealing here with the military, with its own discipline. And can't we have a guru, either a retired military person, to give that civilian feel, if I put it that way, so that at least, because there's no guarantee that those people who will form this very, very important structure, one or two may have quality or qualification rather in terms of military, because this is a specialized field, as I understand it, that will need, therefore, a person, as General would say, a civilian may not qualify much. You would rather have a military person. Perhaps even Honorable Pala may also understand what I'm trying to say. And so what I'm trying to say, therefore, Chair, is only that. But otherwise, I'm really happy. And otherwise, I agree with the colleagues that we'll need to really read more and ourselves. Of course, having got some advice from our content advisors and other people within the institution. But as the presentation, I'm very, very happy that they did actually present it, and they did actually consult widely. They said, they also indicated that December this year is the cutoff date, which means, therefore, we need to rush, make sure that we do meet that cutoff date set out by the Constitutional Court, the 2 years, as the presenter has told us. And of course, in the presentation, it's quite clear that there is a date that is set out there. Thank you, Chairman. Thank you very much, Chair, for the opportunity. You are muted, Chair. We can't hear you.
Can you hear me, honorable members?
We can now hear you, Chair. Thank you.
Okay, no, thank you, honorable Nunkonyan. I was just indicating that can I respond to issues raised by Honorable Mukaye, and on other matters of the process, I would respond to Honorable Gerik, and as well just give clarity to members on where we are with regards to this particular bill. Hence, this particular briefing those that are requesting for clarity and legal advices will come after, but it's issues that I would respond just after you, Colonel. And I just want to refer members to the document that they have, of which is the Portfolio Committee on Defense Amendment Bill to Military Disciplines Supplementary Measures Amendment Bill B31/2025 and the Defense Amendment Bill B32/2025, of which that particular document has been developed by our researcher. The document goes in detail in terms of even indicating the concerns raised by public during the portfolio committee sessions. On page 5 of 13, those who would want to get sense on or who were consulted prior. And I want to indicate as well that the portfolio committee didn't do public participation based on the nature of the submissions and things that were done to process this particular bill. So I want to hand over to Colonel, then just indicate as well on which area are we as the select committee, so that we must not think that they would come back and give us a briefing. The clarity that I'm going to give would just give sense on where we are and where are we going, same as we did with the one of Home Affairs, because it's only small changes of the bill that were effected and the interpretation, as the Colonel has indicated when they were giving some clarity on the presentation. Colonel, over to you.
Thank you, Honorable Chairperson. Maybe looking at the very first question, I must say that there was so much interest in the bill, and some of the provisions that were suggested or recommended were taking into cognizance and somehow ultimately even changed what we had initially written in the first draft of the bill. Maybe I can just give one example. You know, when you look at the composition, actually more of the inputs and comments that we received were on the composition of the committee, which truly also assisted. Initially, the committee had the following. It consisted of a judge, advocate, and a practicing attorney. But in addition to that, we also had the Adjutant General as a prospective member of the committee. There were other role players within the Defense Force itself, like the Chief of Defense Intelligence and the Sergeant Major of the Defense Force. But after a number of comments and inputs came about this, then ultimately the department then agreed, and more so also during the processing of the bill in the portfolio committee, it also assisted, because still such comments they came through. Also the issue of the security of tenure, there were quite a number of inputs there and there, which definitely led to the current position, or rather the current bill, because previously the security of tenure that we had envisaged in the bill, it was 3 years. But after most of the inputs and comments and the work of the portfolio committee, that was amended to 7 years, non-renewable. So most definitely there were inputs and comments received from the public, which really assisted in the making and production of the current bill. as it stands before the Honorable Committee. With other questions, I have my colleagues here. Advocate Ramcharan is sitting right next to me. Can you assist me?
Yes, thank you, Colonel. Honorable Chair and members, as the Colonel pointed out, there was a number of comments that we received that through the process and assistance also with the parliamentary advisors and the portfolio committee that we made changes. I think in addition to that, we then agreed on a lot of the provisions, including the composition of the committee, and more significantly, the year of tenure, which is 7 years non-renewable. With regard to the other issues, I think our colleagues at the parliamentary advisors can also assist regarding the issues such as going through the timelines and the processing. And there was just one particular issue that was raised by one of the honorable members as the issue of the composition and not having a guru or an expert in monetary law. That is why before the committee, we can look into that issue. But I think that's an issue best placed to be discussed further when the Auditor General himself is present as the guru or expert in monetary law. And we can maybe look better or deeper into that issue. Suffice to say, ma'am, we're at the disposal of the select committee and we are here to assist further in explaining any aspects. Thank you, ma'am.
Thank you, colleagues. As I indicated, I just want to check if there are further input, and if not, can I just respond on issues of other matters where committee members were asking where are we in terms of the process? Are we fine? No further inputs on what members requested as clarity seeking questions?
Yes, sir. Yes, Chair. Thank you.
Okay. Thank you, honorable member. So mine is just to indicate to members that in terms of the process, where are we after this particular brief? Is that the committee, the select committee, must advertise for public comments for 3 weeks. Then the presentation on submissions will be done by content advisor and legal advisors will be present. Then public hearings or departmental responses as well as legal input before adopting these bills will be done, as we did with Home Affairs. The very same process would be the one that will be processed as procedure in terms of this particular bill. So I hope it clarifies issues that were bringing some confusion on what needs to be done by the NCOP. So I'm very glad and happy that the department is indicating that they will go with us through the process up until to the finality, whereas this select committee, we will be adopting this particular bill to process it at the NCOP so that it can go to the president for approval. I think members, now we are on the same page, Mas.
Yes, Chair, we agree on the same page.
Yes, thank you, Honorable Mukai. So I just want to indicate and as well emphasize the fact that what has been done by the department with regards to these bills, it's what we have requested based on their space and their environment and what they have presented to us. So with that being said, I want to hand over to the Honorable Minister for her closing remarks. Then we can continue as members on the announcement and closure. Honorable Minister, over to you.
No, thank you very much, Chair, for the opportunity again to come and present to yourselves. And I think, as the Chair is saying, it's been it's been a long process, even from the NA side, since last year that we've been presenting and working through with the NA until we found each other. It was not necessarily an easy journey. There were times we even had challenges about the language, and we spent days just on dealing with technical issues like the language. So the Chair is spot on. He said after this process, as the NCOP goes through this process, we will definitely have the responsibility to ensure that throughout the journey that we'll be embarking with the legal team, which has really been running with this thing for over a year, would be able to clarify and provide support. So just on that, Chair, I want to thank you most sincerely and thank also the inputs that have come from members and also your guidance on the issue, which is extremely helpful. Thank you very much, Chair.
Thank you, Minister. But I think we need to note the counsel by Honorable Nonkonyan to say those who are on the advisory committee, perhaps because of its advocate this and that, we don't have their profiles in terms of when they are appointed, we must get the profiles so we can see if the component that he was raising is there. Because it is important that when we deal with certain environments, we have people who have experience and skills and knowledge with regards to that particular environment. With that being said, we want to thank you for coming before us, Minister. And we hope that with other engagement of military veterans, as the Select Committee, Security and Justice will be prioritized, because there's a matter that is before us that needs your immediate attention to ensure that we deliver benefits for the military veterans. So I hope we would engage and communicate and plan better with your office and our office to ensure that when we have that meeting where we'll be dealing with human settlement, COCTA, and your good selves, we do have your presence, whether as yourself as the minister or your deputy ministers, to come and respond on other issues that we were dealing with, that we need to deal with as well as this particular committee. But with that being said, we thank you for your availability and your department. And we hope that this relationship with regards to this particular bill will continue. Our office will communicate with relevant parties as we will be processing this particular bill. With that being said, we want to just make an announcement for members that on Friday, those who are able to join the Joint Standing Committee of Home Affairs, COCTA, and ourselves, they must avail themselves, because we want to explore if the IEC is ready for the registrations, because we had this particular program for last term, but we couldn't because of the congested program that has been changing. So those who are available, they can avail themselves for that particular session. Because if we're going to be waiting for the next term, it will be late for us to get to engage and advise on things that needs to be done prior to this registration of the 21 and the 22 June, if I'm not mistaken. With that being said, honorable members, the meeting is officially adjourned, and I thank you.
Thank you, Chair.
Thank you, Chair.
Thank you, Chair. Thank you,
Thank
colleagues.
you.
Thank you, Chair.
Thank you.
Sharp, Chair.
Sharp, sharp.
Bye.
Bye-bye. Bukai, who activity?
Hey man, I had an input to make before you close, but no problem. I just went outside. The bus was passing. I thought It's leaving me, passing earlier. You see, these meetings, they go against other arrangements.
The
So I
office is
went
already
outside
guy.
as we were.
Office ya gagwe
I
guy,
went
Scope.
outside as we were closing, but
Office ya gagwe
I was.
guy. Askis.
Yeah?
Office ya gagwe go guy.
Office ya ka e ko parlamenteng.
Le teng mo di office ga rena le meeting tse virtual so that we can be flexible le go re le kry di document to bring out all of you members.
No. That's another issue, comrade.
Okay, sharp,
It depends on your morning. Re tla bua ko officing.
It sharp.